Discussion? All those in favor say aye.
Aye.
Opposed, like sign, motion passes. Item number 6. Discuss and consider approval of fiscal year 2024 line item transfer. Is there a motion to approve the line item transfers?
Motion made. Second.
All right, is there any discussion? All those in favor say aye.
Aye.
All opposed, like sign, motion passes. Item number 7, discuss, consider approval of form for one-time exemption for plating requirements.
The little three-person committee met and discussed these, the other day, and I'm gonna ask Commissioner Williams to correct me if I say anything that was not said in the meeting. It was our bottom line is to do away with this one-time exemption, and we'll start the process right now. It'll be included in the motion and amendment, but there's plenty of ways in our subdivision guidelines to pretty well fit any needs you have if you've got an unusual exception. And so I'm gonna make a motion that we do away with the one-time exemption, and we set a date in the future for a public hearing to hear the public come and discuss this with us, and then we'll move forward after that.
The only addition that I would add there is not we're in agreement here, and specifically the portion that concerned us and the majority of our exceptions are related to when one owner owns one tract and they're going to carve out another, portion, but they're going to continue to own their greater tract. They're just cutting out a part to sell to someone else. And there's an exception, 2 paragraphs ahead of that on page 13 of those rules, says that it doesn't have to come, they don't have to come to us for anything related to that. It doesn't apply. The subdivision rules don't apply when the greater tract remains owned by the seller and they're just selling off one portion of their property. So I'd second your motion, Commissioner Pearson.
Well, basically, your motion is to schedule a public hearing to discuss doing away with the exemption.
That's correct.
Okay,
That's correct.
all right.
So I don't know, Andy, since you mentioned that, this is the item agenda was
approve the form.
to approve a form. So I guess that should not be that way. I'll make a motion to table. I'll remove my motion because it's not on there, the agenda that we're going to discuss the one-time exemption. It's on the agenda to discuss the form.
Okay,
So I'll pull my motion back and
all right.
and I'll make a motion to table this this line item here.
I'll reform my second.
Okay, so the motion is to table line item number 7.
Could I also, Keith, I would mention that there are a few of these that are that are out there, since there's not a hold on, since this is going to, we're talking about doing away with this, those folks that are out there that have a tract that fits in an exemption or in a exclusion in the rules, which is the one that's coming up next on mine, line number 8. There's not a moratorium because it fits somewhere else.
That's correct.
Basically. So we're prepared to move forward. Judge, thank you.
Okay, so motion been made and you second to table item number 7, approval of a one-time exemption form for plating. Is any further discussion?
I'll make a public announcement, just as he said, that all of our guidelines are still in place. We're still moving on. There's the only correction I'd like to do to Cliff's is it doesn't say in letter I of the exemptions you can only create 2 parts, and it doesn't say the owner has to keep the greater part. It says the owner is retaining one of the 2 parts. He's keeping it. whether it be greater or smaller than what he's getting rid of. And it's,
That's true.
Mr. Bass brought this up, and I'm just making a public announcement now. I'm not, not gonna vote on anything. Mr. Bass brought that up in one of our meetings, and I keyed on that, but then I forgot to go back and research it. And so this has been in there all along. It's just been an oversight on my part. I'm not gonna say it's been an oversight on anybody else, but I've flat missed it. And some of the one-time exemptions that I have come to the court to ask the court to give in the past would have qualified under this letter J.
Letter J.
Excuse me, letter I.
Letter I.
Pardon me.
Okay. All right, any further discussion? All those in favor of the motion to table, say aye.
Aye.
Opposed? Motion passes. Item number 8, discuss and consider request for one-time exemption from plating requirements for Dorotha Mums on 4.51 acres sold out of 22 acres located on State Highway 19.
This fits into that I number, letter I. So it's already exempt. We don't need to do anything here. We'll just notify the applicant and the title company that they can move forward with the closing without any further ado.
So there's no motion,
Table,
no action,
or pass, yep.
no action.
No.
But it's gonna happen anyway, right, Cliff? Because letter I.
That's right.
Mhm. All right,
I would make another public comment that the surveyor, just to keep everything on where it can be seen in public, I would put something on your survey that you're doing this and it falls under letter I in the exemptions of why you're not platting.
and be sure to specify the June 26th version of the subdivision guidelines.
Yes, so the current version of something.
Yeah. All right, item number 9, discuss and consider approval of the cottages at Meadowview on Van Zandt County Road 2134, Canton, Texas, located in precinct 2.
The applicant, I believe, is here and may want to make a statement or just be available to answer questions. Woody? Then, in this particular instance, we put all the backup in here. She's provided everything and gone through, I believe you've gone through our engineer related to this, and she's got approvals for on-site septic, and everything is, from my review, appears to be in compliance with our rules and regulations. She's just here for an approval of that information. So in the event that any of the commissioners have any questions related to this, the applicant is here.
Going by the drawing, it says 21 lots, correct? 21?
It's 27 units.
Yeah.
And I will make just quick statement on our goal. So we've lived out here since 2016 and I've been in real estate for a long time. I realized the need for affordable housing. And so that brought this to light where we are building really nice quality products, but we made them a little bit smaller. They're not tiny homes, but smaller so we can offer them on an affordable scale. Energy efficient, and really want to offer that to Van Zandt County. So that is what we are doing.
Rentals or sales?
Rentals.
And each one of the lots, or the average size of the lots is
We didn't section them out per lot. We kept it because we're
One.
keeping it just as rentals. It's still just 1 8-acre tract.
Okay.
Mhm. And then we followed the subdivision guidelines with the
Right.
fine-tooth comb, got all the engineering and everything done.
I saw
So
that.
now we're here.
oh, very good. All right,
If there's no further discussion, then I'd make a motion that we approve the cottages at Meadowview, Van Zandt County Road 2134 in precinct 2.
Cliff, if you would add for filing purposes. Add for filing purposes to your,
Yeah, for filing purposes.
okay.
I'll second that.
All right, motion made and second. Is there any further discussion? All those in favor say aye.
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 Opposed, like sign. Motion passes. Item number 10. discuss and consider acceptance of request for a variance regarding 9 Tree RV Park plat located in Farm to Market 858 in precinct 4.
All right, we're back on this one. Like I stated last time, I wasn't comfortable. I don't know if the commissioner's court has the authority to give this variance, because a oil company and the owner of the property are in disagreement. So, I've got Tonda here today to help me on this, and Kyle here, and I guess Kyle wants to make a statement, and then, we'll go forward with this. We'll see what we can do.
Okay, we've, our attorney has talked to Tonda, and, we are, we've come up with a hold harmless to, execute. It simply states we're gonna hold the county harmless from anything we do, when we cross the easement. And, like we said last time, what we're, proposing is just to cross that 30-foot easement with 4 roads. That's it, no utilities or anything else, just so we can get from one side of the property to the other.
Document for y'all to look at. I have visited with Mike Ken as a lawyer, for Kyle. He works times, Mike is out of town today, I think he's actually out of the country, but, he and I, came up with a proposal that if the court decides to do this, in order to give the county some assurances, that they would execute a hold harmless agreement to the county. Guaranteeing that if there was any litigation in the future over this between the two sides, that, the county would not be on legal fees or damages, in any way.
And that was my concern last Wednesday. You know, I didn't know if, since you got this oil company and Kyle kind of at a disagreement with each other. I just didn't want me or this county or the commissioner's court to be liable in case something else happened. And that's why, you know, I wanted you here, and as you're our lawyer. I mean, if this is fine and doesn't hold us liable, I'm fine with doing it. But I just want to make sure that it's not going to come back on us.
And in talking with Mike, and I know, you know, none of us have a crystal ball in the future, whether Mike would remain their lawyer or not, who knows? The property could sell, but, in talking with Mike, he and Kyle understand that the surface estate is in fact subservient to the mineral estate underneath. So if that oil company or gas company or pipeline company ever decides to use that, they have the right to tear up whatever these folks put on it. And that's between them. If the oil and gas company, pipeline company gets upset at the amount of extra money they're having to spend to tear up whatever they build there, whether it's buildings, roads, or whatever, we're out by this whole garment agreement. So.
Okay, so, and this is,
And well, let's do some background on what we discussed at the last meeting is this is a pipeline that goes through the property that has an easement, and the pipeline has been abandoned for 25 years or something like that.
it's longer than that.
Okay, it's been abandoned for a long time, so that there's very little chance that it'll be used without major work to be used to renovate it. But and so what they're asking is to be able to build roads across that easement, even though a variance in our subdivision guidelines to build roads against that.
I'd make one modification. The easement hasn't been, or the pipeline hasn't been abandoned. I would say in this particular case that the pipeline is just simply not in use, but the pipeline and the easement are still.
Okay.
So
Bayland still has the authority to go and use it if they so please.
If they decide they want to use it tomorrow, they can tear down the building. If he puts a building in the.
This hold harmless leaves the county not liable, correct?
That, and I'm not advising you all whether you want to do this, whether you want to set the precedent for doing it, whatever. But if you are comfortable doing it, legally, I'm comfortable since we have the whole harness.
Well, I'm comfortable doing it and with the county not being liable, I'll motion to give the variance to the 9 Tree RV Park to continue on
And authorize the county judge to sign the hold harmless agreement.
and authorize the county judge to sign the whole harmless agreement.
Well, motion has been made. Is there a second?
Well, there might be, my question is, what are we varying from? What in our subdivision guidelines says that anybody putting in any kind of a subdivision, RV park, rental unit, what in there says that that person cannot put a street over somebody's easement? So I don't understand what we're varying from here. What is this going to do?
That was my question last time. The remarks from our engineer aren't in here. So we don't know what the remarks we're varying from are.
I'm not sure we're not giving this gentleman false hope, saying, I got the county behind me and the county don't have a dog in his fight. So.
And my concern is along those same lines is that if we I think you're saying, and I'm back, and I'm agreeing with you that this isn't really something, this isn't an application that's appropriate for a subdivision variance. And my concern is, and I kind of touched on this last time, is that if we give a variance for an issue like this, that's between two private parties, it could very well open us up to liability in the future. When right now we have no liability. We don't.
That's something I didn't understand from the beginning, is I've read, of course, those June 26, 2024 subdivision guidelines. I don't see anything about this in there. But Kyle and Mr. Cannon are telling me that the engineer will not approve it because of the easement there. So I don't know what guidelines the engineer has that he's trying to enforce that are not in our written guidelines.
What engineer?
Right.
I think something's been taken out of context there. Brian's job is to bring things, he is hired by us to bring things to our attention. So once he brings it to our attention, and he's brought stuff to me and said, I just want to make you aware of this is going on here. And I say, Brian, we're overreaching there. That's not, does not pertain to us. And he says, that's fine with me. I just wanted to bring it to your attention.
And my understanding from Mr. Cannon that it was a holdup from the engineer.
Yes.
But Brian does not approve things. His court approves things.
That's right.
So
And so all Brian's got to do is put his note on there, FYI. Some of these roads cross an easement with a pipeline under it. Hey, thank you, Brian, for letting us know. He did his job.
It doesn't, in my opinion, it doesn't expose us in any way, but giving a variance does expose us, because then future litigants can come back and say, well, you gave them a variance. You got a variance and you got to hold harmless against them when it's an issue between two private contracting parties. It has absolutely nothing in my mind to do with the county, and it subjects us to liability.
You whether to issue a variance or not issue a variance. I'm just saying, if you do, please get a hold on us.
So from what I'm gathering y'all are saying, I'm getting educated in law school here, is we don't need to grant a variance because they have a whole harmless agreement between themselves and it leaves the county unliable, so we don't have to grant them anything.
No, there's not a hold harmless between them. They can go at each other all that they want to. By us giving him a variance or saying it's okay for you to do this, and we're not in it, you'd have to pay our defense bills. if we did not, if we do this, then we are included in it. He just has to pay our defense bills. And anytime there's ever anybody else that has builds something over a pipeline, now the county can be included in that. And I know that, you know, these are very legal concepts, but I believe that, as Commissioner Pearson said, there's not a reason for a variance because it doesn't touch our subdivision. This is just an issue between them. It's like saying somebody comes up here and says, their fence is built over my area on my land. I want the county to give me a variance from the subdivision rules because his fence is, if we get involved in each one of these things, then future litigants can say, you're involved in these all the time. You give variances and you gave a variance as long as they sound to hold harmless. So it opens us up to an entire area of litigation. I don't think we need to be.
So the whole harmless would be between the oil company and them.
There's not a hold harmless.
Not the county.
Yeah,
County
there's
shouldn't
not,
be involved in anything.
there's not a hold harmless involved.
As I understand it right now, the engineer is telling them they need X between the two parties. Mr. Cannon, Kyle's lawyer, doesn't want to do X. He wants approval for this without doing it, without signing that document between those two parties. For some reason, the engineer is not sending it forward, putting his stamp on it for you guys, whatever, until the issue between those two is settled.
Can we just direct Brian Abbott that we're made aware and we appreciate his review? I think that's where that should be our position.
And we don't have to approve anything. They can just go ahead on with their
We
business.
still have to approve, here we go, here comes, this is great, here comes great.
There's Brian right
We
there.
followed all of the rules as far as the subdivision, you know, that, but our holdup is that Mr. Abbott has told us, we have to get approval because of the pipeline. You know, this deal with the pipeline.
Well, that's good. Mr. Abbott just came in. Brian, thank you for coming. I was just explaining to them that it's, I think there's some things taken out of context here, saying you're not approving. I said, Brian doesn't approve things. He brings things to our attention. Correct me if I'm wrong.
That's correct.
And he tells us things and say, hey, is this okay with you? Is this okay? It's, you know, and that's Brian's job. That's what I just explained to him. So I was telling this gentleman here that I believe all it's got to do is Brian is making all parties aware that you might want to do this. It's not Van Zandt County telling it. He's just doing it as a professional to let everybody know.
Right.
So correct me if I was wrong,
No,
Brian.
that's correct.
So,
And that was my question through the few meetings we've had over this. No one has brought your remarks. And that's what we vary. When you make a remark on something that this is out of alignment with a subdivision policy, that's what we get the variance on. And I have not seen your remark to even know what we're trying to give a variance on.
What part of the subdivision rules did you have in mind when you were saying they may need a variance of some sort?
What is it? Which part are we talking about?
Trail.
This is the roadways
pipeline.
going over
The
the
gas
easement.
The gas pipeline?
Yeah.
I don't know if there's anything specific in the subdivision regs, but as just as an industry in development, that's a very typical thing to check.
Oh, yeah.
On the property.
Because if the pipeline company wanted to come in and do something in their easement, just like cutting trees overhead, they could also bust up the roads.
Correct.
That's right.
They do, they got anything now. So more of a protection of not only the county, but the development as well, if they didn't know about it.
But if that's the case, they can go do that. That has nothing to do with the county. That would be between the owner and the gas company, right?
correct.
Where
So-
I would be looking at concern would be if he was actually putting lots on these.
That's true.
That would have someone sleeping in the camper on the easement, and if that line went, they're there.
Right.
Or if somebody built a subdivision that's trying to put lots on top of the easement, I could see an issue there. And so your remark was simple, yeah, it's just roads, but y'all need to get with your pipeline company and.
There were some utilities shown in that easement too, that, so between the roads and the utilities shown in that easement, that's what kind of flagged for me. Just hey, heads up, there's stuff going on in this easement that is shown on the Texas Railroad Commission hotline map.
Pipeline easements are different than other easements. They got all kinds of authorities they can do, and they got all kinds of regulations they have to follow. It's not like a standard easement.
Well, even if, in my opinion, even if utilities did go over it, or if if one of your lots, or let's say one of the houses from the prior number, if those were built on it, it still doesn't have anything to do with the county or the subdivision regulations. That's a private matter between two equal litigants.
Right. And we've tried to address everything there when we designed this. We have all the utilities are separate, the only thing going across is the electric. And that's, that's got to cross because of where it comes in.
Going in the air or underground.
We talked to Wood County, and we can either go across it in the air, which they've already done. Or they can bore about 4 feet under that pipeline, 4 to 5 feet under that pipeline.
Is that primary electric run into the property?
Right.
That's not from lot to lot.
Right.
Okay, because subdivision regs require.
Yeah, it's just, one time under that line. And then it loops on either side. It's same with water, we've got 2 meters, one on either side. So that they're separate, and then our septic tanks, one on either side. So we don't have any water or internal electric or sewer crossing in that easement. Or crossing the easement. The only thing crossing is the 4 and then we've got, ingress and egress on either side of the pipeline, so if they took out a road, people can still get in and out to their place without having to cross back and forth over.
So we don't need to approve anything, just, once again, my main concern was if something ever happens, I don't want us to be liable.
Well, we'll still be approving the RV park eventually.
Right.
Uh,
I'm talking about something happens with this road, they can come back and, that was my main concern, is that we're not liable for anything.
So you're withdrawing your motion, right?
or it dies
Yeah.
from lack of service.
Dies from that. Okay, that's the last thing. All right, any further discussion?
Well, I guess, so we're saying from our perspective, we don't have a dog in that hunt.
And in my opinion, that won't stop the approval of that particular item, won't stop approval.
Right, as long as everything else is in line.
Right.
Yeah,
I'm not speaking for the rest of the court, I'm just speaking for me.
correct. Yes, sir. Yes, sir. Thank you.
Finally got it cleared up.
All right,
One man.
No action.
no action. Or dies for lack of saying. That's it. Item number 11, is there a motion to adjourn?
Yes, sir.
Second?
Second.
All right, all those in favor say aye.
Aye.
Opposed, like sign, motion passes. We are adjourned at 9 o'clock. Thank you, gentlemen.
Thank you.
They called me to get up but she didn't say. She had one for me. When I go back in there, I'll bring you.
You got a moment?
Your phone.
Well, I'll do it.
That's right. That's right. That's right. Yeah, and I'm pleased with this, with the way we've done it. That's the best way for just to keep our nose out of it. But
Where's your limit? What do you want us to do?
yeah.